When you boil it down to the student or client service level, our most fundamental deliverables require that we share information. We can't do these very basic service delivery elements without having access to one another's information. The very fundamental delivery of care to students, clients, patients is information dependent. So we have this huge obstacle, because the more we try to fix this with legislation and lawsuits, the more we get wrangled in layers of bureaucracy and conflicting policy. And so we got a big challenge, and we've got some terrific folks today that are going to speak to this, because there are some things we can do, and there are some things happening here in California. So let's talk about that with our esteemed panel members, who I will introduce to you briefly. I'll draw your attention again to the biographies that are in your symposium guide, but let me reflect briefly. Pleased to have with us Dr. April Fernando, who is a policy fellow at Chapin Hall. She assists with the development, implementation, and utilization of transformational collaborative outcomes management, which some of you will know more succinctly as CANS. And she's worked with both mental health and child welfare systems in California. I just have personal appreciation for April. She has been the most patient consultant to the State Department of Social Services and Healthcare Services as we've tried underneath the continuum of care reform to build in CANS. She's been our most trusted ally in that regard. Elizabeth Estes is an attorney with the firm of Atkinson, Andelson, Loya, Rude, and Romo. You know Elizabeth as the founder of Breaking Barriers. She comes to this work with a tremendous personal passion rooted in her experience as a survivor of trauma. She, of course, has technical expertise in information sharing specific to young people in our systems, and she is going to partner today with Rebecca Gudeman, who's a senior director of health at the National Center for Youth Law. She specializes in issues of health access for youth, including consent, confidentiality, and information sharing. In addition to her advocacy work, she trains and consults nationally to help public and private systems better collaborate and deliver care. You'll note that in 2016, she received the National Chapter Recognition Award from the Society for Adolescent Health and Medicine. And Daniel Stein, you have met already and heard from him, and we'll hear a little bit more from him as we proceed today. So a moment of pre-appreciation for our panel, if we can. Thank you. Let's first turn, April, to you, and if you can share with us a little bit about what some of our local efforts have been in California to use CANS to solve this fundamental challenge, particularly as it relates to our mental health and education partners. That would be great.
Thanks for having me this morning. So I'm going to talk a little bit about what's going on with the CANS in California more specifically, but also might dip out of state a little bit to give a little bit of context. So many states and jurisdictions, including California, have realized that for CANS to move past a documentation mandate, which is how it's been rolled down mostly, in order for it to be a communication tool and, as Richard puts it, a planning information device. Richard likes to say things in cool ways. The focus actually of the CANS has to be on practice and how the process of using the tool can impact outcomes. And I want to thank Daniel for paving the way for my comments, because he's clearly a transformational change guy, and I appreciate it. So there are 4 areas I'm going to outline where work has been done, but work still needs to be done. So first is CANS within a practice culture. We've learned that beyond teaching folks about the tool has to be embedded within the practice culture wherever people are at. Luckily in California, we have such a thing called the integrated core practice model as the practice of culture for both child welfare and behavioral health. So this helps not only to create buy-in for providers, but it also provides them a context for using the tool in their work. So without that, it remains a form that must be filled out. So the ICPM, or the Integrated Core Practice Model, as you know, outlines those values, the practices, the behaviors that are central to coordinated care, and all of those things are perfectly aligned with the philosophy that underlies the CANS, which is, as Richard said, the Transformational Collaborative Outcomes Management approach. The second thing is looking at CANS as a communometric tool. So communometrics in the last few years, which is the science that underlies the CANS, has become more prominent in the last few years and been highlighted in many implementations, particularly as it's being implemented right now in the Department of Social Services. So looking at CANS beyond certification is important in two ways. First, it's the way in which the tool is introduced to children and families, right? It has to be introduced to children and families so that they understand the way that they can participate, engage, because it empowers themselves as the tellers of their own stories. Second, it's how the tool helps to build team consensus, right? And get everyone on the same page so that it supports coordinated care along with giving voice and choice to children and families. The shift towards communometrics, however, has challenged a lot of the earlier implementations of the CANS in California and in other places around the country and around the world, right? Those early implementations tended to focus on the tool as less of a consensus building approach, but more part of the expert system, right, where the expert professional completed the tool following their collection of information from all important people, right? So these established implementations have had to shift or reboot, so to speak, so that they can integrate more of the consensus-based approach that is the core of communometrics. Now, transparency and consensus building in a person-centered tool has its challenges, and you've heard already Richard mention some of those challenges. And that it has to do with information sharing and the rules we have around information sharing from the different system perspectives. So the way in which privacy and confidentiality is being interpreted, and in California there are at least 58 interpretations of that, and the challenges that have to be overcome in sharing information is very daunting. And this extends and is most prominent in teaming environments, such as the child and family team, wherein which the CANS has been mandated for child welfare, right? Because there are informal supports in the room as well as formal or professional folks. And then you've got team members that could change from meeting to meeting that make the universal releases of information helpful, but not quite enough to solve the issues. This is not only an issue in California, it's an issue across the country that folks are still grappling with. It tends to be easier in state-driven systems versus county-driven systems, but there is no one magic bullet solution to address the information sharing issues that are central to the CANS being useful. Communometrics impacts process, and therefore it impacts clinical and social work practice. We are hearing, however, of positive results from taking on the communometric approach from new implementations in Colorado, in Idaho, and closer to home, San Diego County has kind of been a leader in showing, as for a new implementation, some of the benefits of the communometric approach. Planning is another area. We've always integrated planning, whether it's case planning, treatment planning, care planning, as part of our training of the CANS, but it's not necessarily been evident or explicitly integrated into those planning processes. We are now starting to see that coming to fruition, which is really amazing, right? And it's picking up some traction, and it's actually the most requested training that we have at the Parade Foundation to help people learn how to do collaborative planning using the cans. And there are some electronic platforms that are housing the cans that are now integrating planning into their electronic process, specifically tracking the items that are integrated into the plan from the cans so that we can see change over time and outcomes related to specific interventions or services that are being provided. So that's very positive. The last area I want to talk about is the data capture and reporting aspect of the cans, because it's very important in the approach to work towards the goal of one cans, one child across all systems. And this is very, very complicated given that we have a mental health system that's episode-based on programs, not on people. So we still have some systems where the cans is being used, where every episode that's open, there is a new intake process that's triggered and a new cans that's generated, which goes, again, against the philosophy of the cans. There are some mental health plans. I would say that Alameda and Santa Cruz are among many that are trying to figure out how to not have multiple cans for multiple children based on episode openings. And we're working really hard with them to help them try to figure that out. Because the implications for multiple cans for children is not only do providers need to understand that, but the CQI staff need to understand it as well, right? On the practice side, we're risking re-traumatizing our children and their families every time we do an intake with them, right? And we're also risking multiple treatment plans, multiple case plans that do not align with each other when we have multiple cans that do not align with each other. So it's really important that we figure out how to data share and have systems that share data with each other so we can achieve a one cans, one child approach in California. And finally, on the topic of feedback, right? We know that implementations across the country that are more mature than California have had various degrees of success because of not having data systems that don't just capture information but feed information back, so as Daniel said, the information can be useful, right? And so ensuring that our systems are able to not just capture the information but provide feedback in ways that are useful, right, are really important. My colleague Kate Cordell here is working really hard to help systems understand how to create feedback loops that make sense to providers, to social workers, to clinicians, so that the data isn't just, great to have, but it's helpful to have as well. And that's something we can share directly with children and families, because when the data matters to them, that's when transformational change happens in their lives. Thanks.
April, thank you. Rebecca and Elizabeth, I know your work has put you in touch with both the capacities and the limits of CANs in a teaming environment. You see on a daily basis the need for solutions in this area. And of course, there are issues way beyond CANs as a unified assessment that we're wrestling with in terms of privacy information sharing. You've got some information you'd like to share about that.
Well, I think,
Yeah.
so in the spirit of collaboration, Elizabeth and I decided to sort of merge our presentation and talk both about CANs and about sharing in school health environment. As lawyers representing different confidentiality laws in different spheres, we figured we would model what we're all hoping to see in doing this, but and talk first about some overarching principles and then the two examples. So,
Yeah. So we're gonna do a little PowerPoint. Can you guys hear me? No. Hello? No.
no.
There we go.
Yeah.
Hello?
Yay.
I'm incredibly technologically challenged. We're going to do a little PowerPoint on some information that we put together. I just want to say we met because I have worked in the social services and education space serving children for 25 years. And Rebecca is a children's attorney who has expertise in both of those spaces as well for the National Center for Youth Law. But I have always represented either education and or minors in the social services system. And so a couple of years ago, I was reading some publications that Rebecca had put out with relation to Hipaa and Ferpa and information sharing across those divides, which I know can be incredibly relevant to the work that we're doing here. And so I think I literally just reached out and said, you know, we sort of need to know each other, and we need to figure out how to put our minds together to tackle these issues of Hipaa and Ferpa, so that we can advise the world that we advise in a way that's informed by both of our perspectives. So that's what we've been doing ever since, and it's been super fun. And so we put together a little PowerPoint, and then she has some thoughts on the cans. I have some thoughts on the cans. So we'll get into it. So we want to do that? Yeah. Do you want to stand up there together? Because we're kind of.
Sure.
We have to tag team.
Yeah, we're supermodeling collaboration
Yeah,
here.
we're going to supermodel collaboration. Okay, so for our presentation, we're sort of taking it down in many ways to the micro information sharing that you all are doing on a daily basis. And one of the things that brought me to this work was having practiced in the welfare areas first, representing minors in the dependency system, and then transitioning to education and representing school districts, and then sitting in meetings and seeing the absolute divide between social services and education for children that we were serving simultaneously, but not together. And that absolutely impacting their experience in the world, and sometimes, frankly, resulting in re-traumatization of children, which, when I think about the CANS implementation and the fact that, you know, that is not coordinated at this point with education, and we're doing our own assessments, and those aren't necessarily coordinated. I mean, that is of great concern to me for kids and families, and I think we need to be talking about it. And forums like this are the ones where I hope we have those conversations. And I know, as I said the first day, you on the ground are building the solutions and really tackling these issues. So we learn from you as much as you learn from us. So our purpose is to find ways to connect child serving systems in expanded, effective, and accessible care. Either macro or micro data sharing comes up. So we're going to talk a little bit about both. Micro is what? It's one child, one plan, micro data sharing for one child when multiple agencies are touching that child. Macro data sharing is sharing information that we're all gathering across these agencies that we're not sharing, that we could use to improve our service delivery systems. And so we touch both. And when someone calls me and says, we need to deal with data sharing, I'm like, what are you? You need to define for me what it is you want to talk about when you tell me you want to talk about data sharing and improving data sharing in your county or in your district or across whatever agencies. So that's what we want to talk about. Why does it matter? Well, we've already talked about this a little bit, but we have needs for privacy of information. That's important. That's incredibly important. And it improves access. Privacy. Knowing that information can be maintained private, that improves access. But sharing information across our systems can also improve access. It can also improve efficacy. It can also actually keep people from being re-traumatized by the disconnect between the systems. And it can absolutely improve the breadth of available services and the coordination of that care into a continuum that's effective for children and families. So it matters. It matters for both of these reasons, or all of these reasons. What does that feel like sometimes? Doesn't it feel like this sometimes? Like, you know, privacy, data sharing, privacy, data sharing. And sometimes what happens is that this tug of war that goes on becomes the barrier this becomes the barrier, and this is where we stop. This is where we stop. We go, no, no, no. We can't breach one, and we can't do the other. And that's where we live. That's where we spend so much of our time in this sort of debate and really trying to ensure that we have privacy and data sharing. And so the work that we want to talk about and the work that we do out in the field and the work that we do as attorneys in this is to find this. That this can happen. And a lot of you know that. A lot of you out there, I mean, I want to hear what you guys are doing because a lot of you out there are finding solutions to that and finding this balance. And that is so absolutely critical, and it's possible. I think the message that we really want to send out there is it is absolutely possible. So I'm going to turn it over to Rebecca to talk about that.
So we're going to talk about sort of the possible a bit, and when we're looking at how do we find that balance, what is that balance created from? In a large part, it comes in sort of the most basic instance from the laws. And I think it's just important to define what those are because to the extent that we've got that many different information sharing models out there, it is really important to acknowledge that we have literally dozens of confidentiality laws that could potentially come into play depending on the funding stream, the type of service, the information, the professional license of the person connecting with this individual. And that can feel daunting, but when you boil them down, they all have this in common. We recognize, the reason we have that law in the first place is we recognize that there is some personally identifiable information which for various reasons we at a core level feel is important to be able to have some control, some privacy, some ability to shape who has access to it. All of these laws will say this information and define what that scope is protected, and then they will lay out when and what information must not be disclosed, when, what, and how information must be disclosed, and then there's this space where they create some opportunity for sharing when it says, look, in these situations, this information may be disclosed. And that is where we're really looking to dig in when we're trying to create that balance and leverage the ability to coordinate. Now, how many of you have heard, well, I can't because of HIPAA, or I can't because of confidentiality law, right? Like that's really common, yeah. So one of the messages we want you to walk out with today is often it's not because of the law, it's about how we work in that space in the middle. It's not just the law, it's not just HIPAA, because when we're leveraging the opportunities to share that are in each of these laws, there are factors that can come into play about someone's willingness to share information. It may be their ethical or professional practice standards. So, you know, maybe I'm a mental health therapist. I say, well, I know that the law allows me to share with your agency, but my ethical duties and the promise that I have made to my client says I need to keep this confidential until I get their permission. That's important. That's not about HIPAA, though. That's about these other issues, and we need to acknowledge that and recognize that we have folks around the table who are coming in with this other training and other ethical obligations and figure out how to work with those. In the same way, it could be relationships and trust. You know, maybe I've worked with Elizabeth. I trust you. I'll share information with you, Elizabeth. But I know that if that goes back into the file in your department, there's that other social worker who has used and abused information and could use it to hurt this client we have in common. So sorry, even though I love you and I've worked with you and we've worked together well, I may not share. That's important too. That is a reality about why people sit around a table and are ready to share information or not. Also defining what is appropriate to share. You know, do you need to see the whole file, or do you just need to see the conclusion or the diagnosis, or this is how many service interactions they've had, or this is, you know, yes, they have an IEP, or no, they don't have an IEP. All of these other factors can come into play when we're trying to shape an information sharing protocol and figure out how not to duplicate, but also to honor that important space of privacy too. So what we thought we would do is walk through 2 examples of sort of how this can come into play and show why this ends up easily sort of people throwing their hands in the air, but also some of the ways that we've been trying to work to help folks figure out these sort of very local, how do we create information sharing. So the first example is child welfare, and we thought we would leverage the fact that we're talking about CANs and child and family teams and sort of the new models that we're bringing into play. And it's a great example because child welfare is one of those places where we've got so many different folks who play a really critical role if we really are trying to make a difference in the lives of a young person and a family. It's their family, it's the child welfare agency or the probation agency, or perhaps both. It's certainly mental health and behavioral health. It's education, which, as Elizabeth often notes, sometimes gets left out of this loop, but also plays a critical role. It's the caregiver, it's health. We all understand at a core level why each of these folks need to be at the table and need information. The caregiver needs to know why that young person isn't sleeping at night and what they can do to help address the trauma that they are living out in their dreams. The mental health system needs to be able to coordinate with the health system when we have young people with complex issues. But, you know, so all that is obvious. But what I also love, and I love we have Antoine over here too, because we have to remember that young person at the center. For all of those folks around here, it's really easy for Antoine or any other young person to completely lose themselves if information is just completely open and available to everyone. We've had young people who say, you know, I'll go to a school, a new school, it's the 3rd school this year, and before I even walk in that door, they know that I was arrested for stealing food 6 months ago. And they know that I went into a psychiatric hospitalization after a 5150. And I don't get a chance to introduce myself, who I think I am, who Antoine is, before they already have this image of me. And it's really important for us, as Elizabeth said, to also acknowledge and keep at the core of what we're doing. There is a reason we have these privacy laws, and there is a value in trying to find a way to share what we need without completely losing that really core part of privacy. Okay, so child and family team is a great example of where we need to create these new information sharing protocols. We now require both child welfare and probation to use child and family teaming as a way to create, to inform case plans, to both acknowledge the strengths of young people and recognize their needs. Those child and family teams are supposed to be informed by a CANS assessment, and that is supposed to be brought in. But you know, as was noted by April, we have different folks that may be coming in or out of that team. And just in terms of the law, how this gets really tricky really quickly, let's say we have mental health wanting to sit at that table and share out their CANS assessment. Or maybe they need to share with the agency, they need to share with child and family team, maybe they need to share with the school because they're working on an IEP. We don't want to duplicate the CANS. That sharing, that arrow, is subject to one set of laws. It's subject to Hipaa, it may be subject to the California Confidentiality of Medical Information Act or Landerman-Petrie Short. So that's just one person at that table. Now, let's say the agency, child welfare or probation, wants to be able to share information at that table. We got these other sets of arrows. That's subject to another law. That's subject to Welfare and Institutions Code 827, which, by the way, there is no release form that you can sign to release information. So there's different rules in each of these about who can get information and what tools you can use to disclose. And then we've got education at the table. Education wants to share with all these folks. Well, guess what? That's a different law. And I could start going on, and each of these arrows, it's a different color, those are different laws. And my ability as mental health to share with education is subject to one law. Education's ability to share with me as mental health is subject to a different one. I may be able to share with you, you can't share with me. Unless we have all sat down and mapped all of this out, it can lead to a lot of frustration and a lot of confusion. And these arrows can quickly get overwhelming and lead people to put their hands in the air and give up. But it is possible to map this out and find a way for the folks at the table to share the information that they need. It just takes that work up front. And so I think we will move on to our next example, where we're going to talk about how you can actually do that, to sort of sit down and make that happen. So I think I'm passing to you for this next example.
Okay. So we wanted to talk a little bit about Hipaa and Ferpa, but I think Richard's telling me we have 3 minutes. 3 minutes. So Hipaa and Ferpa in 3 minutes. This was not, we both do, and we are going to begin doing together a Hipaa Ferpa training out in the field. So we do that, and it's not 3 minutes long. So, but we wanted to just touch on the issues of Hipaa and Ferpa because they become such a real issue in the work that we're doing. And this is just an example that comes to us regularly, and I'm not going to go over it because we don't have the time. But what happens when we break barriers without addressing the law? If when you are coordinating across, when you're coordinating and you have Hipaa and Ferpa at play because you are doing health services in an education setting or coordinating across health and education providers, if you have not figured out before you start to do that work together whether Hipaa or Ferpa governs the work that you're doing and what information you want to share across agencies, and then how you're going to do that, then the chances of you ultimately violating one of these laws or both are, incredibly high, if not, absolutely certain. You have that initial work to figure out, everybody wants to do good, we all want to coordinate, we all want to help, we all want to provide more informed, better services to children and families. But if you just jump in and go, hey, let's do it, and you don't think through these legal issues, then I can tell you there are multiple circumstances for both Rebecca and I where really well-meaning people have jumped in to provide service delivery systems, and we get involved and look at it, and we're like, oh my gosh, there's like so many legal violations here right now. So I can't encourage you enough to just have the conversation about, are we Hipaa governed, are we Ferpa governed, and then what information do we really need to share, and with who, and when? The situations when you all need to information share, they're not unknown to you. Are they? Do you not know when you need to share or want to share information? For the most part in my practice, we actually know, but you have to have that informed conversation. They're both laws designed to protect confidentiality of health and education information. They both do allow for sharing of information with a consent to release that information. They both contemplate, even though some people go, no, can't do it, it's Hipaa, or can't do it, it's Ferpa. They actually both contemplate a sharing of information for purposes of coordinating and collaborating, and they both allow and actually contemplate de-identified sharing of information in order to have improved service delivery. So there is an intention in both of these laws to actually be able to share information, but we have to just think through the specifics of what are we sharing and how do we do that sharing within the confines of the laws. Incredibly intentional work, but very doable, and many of you are doing it. You've tackled this, right? Who's tackled this and sort of feels like they've worked through it? And who's still like, whoa, we really don't even know what you're talking about? Either one is fantastic in this room, because that is the whole point of this forum, is to learn from one another about who's doing what, who's getting where, and to coordinate our care. Okay, I'm not going to go into these tips, but you're going to have them, and I'm going to stop because I know that we have to. Richard's going to get mad at me if I don't.
And I'm bad when I'm mad. We're not done yet, but thank you for that. Daniel, can we check in with you for any reflections and just get a 1-minute perspective? Is there a tool on the national frame that we're missing in California? Is there an idea or a construct out there that we're not aware of?
Maybe. There are a couple of things I didn't show on my slide that are happening at the national level. One is called TEFCA. You guys familiar with TEFCA? Trusted Exchange and Common Agreement, which is on the healthcare side trying to align all of the health plans, providers, and payers to develop a common agreement to be able to share health information across everybody all the time. Not all the time, but across everyone. So that's an important consideration that we think about, because there's recognition at the federal level that needs to be, again, more common agreements. And that would be something that I don't know the specifics of it as it relates to sharing outside of the healthcare world, but there is that common agreement that is beginning to be put together, which is really vitally important. Still in the final review, I think, of the Office of the National Coordinator I think the review process is just closed, or it's in the process of closing shortly. So there's contemplation of being able to share that. So that's one thing. There is a couple of other things within the health field that are recognizing the ability to share information across state lines with electronic health records that are also useful to think about. And if those things can be extended, there are trusted agreements that are being put in place that are digitally secure. So there's an existing trust agreement that identifies you or your organization and you as a trusted receiver of information, and that avoids a lot of the need to sign consents every time, because you're recognized as a trusted recipient of that. There's a bunch of that's happened in the Homeland Security space. After I was mentioning to somebody during the break that after 9/11, the Congress had put together an office called the Information Sharing Environment, which reported into the White House, which was actually trying to facilitate sharing of information between security agencies and Homeland Security and police and those kinds of things, law enforcement. And so there's some models there that have been developed around, as I said, digital trust agreements that might be things that we can bring over into this space without having to recreate them exactly.
Interesting.
And one question, I don't know if you, within the SAMHSA world, I think there's something also, something called consent to share, which is another effort by SAMHSA and 42 CFR to, I wouldn't say make it easy, but to sort of standardize the approach to sharing that information. Mm-hmm. So I think it's important that we keep our eye on, again, I always go back to health because it's such a big player and such a big consumer, and it touches everybody in so many ways. There are things that are happening there that we're trying to wave our hat and saying, don't forget us here, how does that apply to our work as well? So those are just a couple of the things that we want to be aware of.
Appreciate that. I know that we do have help on the national level from this. The Office of Civil Rights a year ago released an inquiry from states and counties acknowledging basically that HIPAA had been overweighted, overinterpreted, and overutilized, and it was an obstacle to care, and that they are currently reevaluating how to train or educate specific to HIPAA to support counties in regards to fixing this problem.